Hi everyone, this is Erica from Gokce Capital. Today we're going over buying landlocked properties and the 11 things you should know before you go ahead and purchase. So you'd be surprised at how many properties are landlocked in the US, especially when you're looking at rural vacant land. And you may think that this wouldn't be the case, but if you have been looking at a lot of rural parcels, you have probably already run across a couple landlocked properties. So if you're thinking of still purchasing one of these, here are 11 things that you should know before you go ahead with that purchase. So the first thing is to actually understand what landlocked means. So a landlocked property is a property that does not have access via a public thoroughfare. Basically, it means that the property does not have legal access. It's important to note that this does not necessarily mean that there won't be physical access. So there may be a dirt road leading to the property. It just so happens that that road is not a public road, in which case the parcel is technically landlocked. This also means that in order to access your property, you will need to pass through someone else's property. So again, in the example of a dirt road, there may be a dirt road that runs through your neighbor's property to your property, and that road isn't public, so technically the road is part of your neighbor's property, and in using it, you are passing through their private land. Number 2, what constitutes legal access? So I got into this a little bit in the last pointer, but legal access is a public or legal right-of-way. And here are a few examples. You have a public road, which is how most of us access our homes. You can also have a platted road in a legal subdivision. So sometimes you will see properties that don't have physical access, so there is no road, physical road leading to the lot. But if you go into the county records and look up a plat of the subdivision where the property is located, you will see that there were roads platted in at the time that the subdivision was created. So in this case, you do actually have legal access even though the road isn't in existence. And finally, you can get access use conveyed by an easement, which we'll go over shortly. Okay, so number 3, what are my options if I do have a landlocked parcel? So broadly speaking, you do have a few options. The first is to enter into a verbal agreement with the neighboring property owner, basically getting their verbal okay that you can use a road on their property to get to your lot. This is what happens in a number of cases with landlocked parcels, and it can work for a while, but it's very important to note that you have no protection with this kind of verbal agreement. So if your friendly neighbor sells their lot to a corporation or to someone who's less friendly, you may suddenly find that your ability to access your property has been taken away. A permanent or more permanent option is to actually get that agreement with your neighbor legally codified through an easement, which again we'll go over in the next couple slides. But this is the best way to gain access if you have a landlocked parcel, and it does convey a legal right to you, even if your neighbor sells. And I'll also note that in some rare instances, you can also petition the county or local jurisdiction to develop a public road to your lot. This is probably not going to be a feasible option in the vast majority of cases, but it is sometimes an option. Okay, so I've talked now a little bit about easements, and I'll give you a definition of what an easement actually is. So an easement is an agreement between parties that gives one party the right to use someone else's land for a specific purpose. In this case, what we're talking about is an access easement, so it would be an agreement between you and your neighbor that allows you to use your neighbor's land to access your property. And easements can be obtained in a number of ways. So before purchasing a landlocked property, you're going to want to try to suss out how difficult it'll be in your particular situation to obtain an easement. And generally speaking, the level of difficulty is going to depend on the owner of the adjacent parcel. So the easiest way to get an easement is to just go over, talk to your neighbor, explain the situation, and ask for an easement. Now, oftentimes they will want some form of compensation because you are encumbering their property with a legal burden, essentially. But you'll find that there are many people who are willing to grant you an easement, especially if you're willing to pay them something for it. So if you're able to talk it out and reach an agreement, you can then simply draft up an easement agreement, get it signed and notarized by your neighbor, and then have it recorded. However, if you are not able to work things out with the neighbor yourself, you'll have to bring in a lawyer. And your lawyer can start by trying to settle with the neighbor out of court. And of course, as soon as you have some conflict, the certainty around being able to obtain an easement dramatically goes down. And as soon as you have to hire a lawyer, it's going to become more costly. And then finally, if all else fails, you can take your neighbor to court. If this is the only way you have to obtain an easement, you will want to talk to your lawyer about the odds of prevailing in court, especially if you haven't bought the property yet. Because you most likely won't want to purchase a property if your lawyer is telling you it's very unlikely that you'll be able to win an easement. Although there are always exceptions to that. So this gets into number 9. As you can tell, it's a good idea to have local counsel when you are talking about easements. Potentially, if you're able to work something out with a friendly neighbor yourself, you won't need counsel, but even in that circumstance, it's a good idea to have a lawyer's take on the situation. And this will ensure that everything is done properly. A lawyer will also help you understand what your full suite of options are, because there are other ways of obtaining an easement in certain specific circumstances. So there are a couple kinds of easements that can come into play again in certain circumstances. These include easements by necessity, implied easements, prescriptive easements, and easements by estoppel. And I'm not going to go over all of these in this video, but we do have a blog post that covers them. So if you're interested about any of these, go check out our blog post, and I'll include a link in our description. So finally, the last thing you will want to know is what your responsibilities will end up being as an easement holder. And responsibilities primarily for maintenance of the portion of the land burdened by the easement are going to be spelled out in the easement documents. Typically, the property owner retains responsibility for maintenance of their entire parcel, including the portion covered by the easement, but sometimes that may not be the case. So you'll want to understand what your responsibilities are going to be moving forward. And so that's it for this video, but as I mentioned before, we do have more information in our blog post. So if this is a really important topic for you, you may want to check that out. And then finally, if you're not familiar with us, we are Gokce Capital. We buy and sell vacant land, and you can check us out at gokcecapital.com. On our website, you'll see all of our properties, as well as our land investing program and our free land giveaway. And of course, feel free to leave any comments or questions on this video. So thank you for listening, and more to come.